Hi, good day everyone. I will read the whole Article 6, which is the Legislative Department, and then I will insert explained cases by the Supreme Court. And by the way, I will be standing up until I finish this work. I hope you do too when listening. So if you're not yet subscribed to our channel, hit that subscribe button and let us study together while staying healthy. Thanks. Section 1. The legislative power shall be vested in the Congress of the Philippines, which shall consist of a Senate and a House of Representatives, except to the extent reserved to the people by the provision on initiative and referendum. Section 2. The Senate shall be composed of 24 senators who shall be elected at large by the qualified voters of the Philippines, as may be provided by law. Section 3. No person shall be a senator unless he is a natural born citizen of the Philippines and on the day of the election is at least 35 years of age, able to read and write, a registered voter, and a resident of the Philippines for not less than 2 years immediately preceding the day of the election. Section 4. The term of office of the senators shall be 6 years and shall commence, unless otherwise provided by law, at noon on the 30th day of June next following their election. No senator shall serve for more than 2 consecutive terms. Voluntary renunciation of the office for any length of time shall not be considered as an interruption in the continuity of his service for the full term of which he was elected. Section 5, Number 1. The House of Representatives shall be composed of not more than 250 members, unless otherwise fixed by law, who shall be elected from legislative districts apportioned among the provinces, cities, and the metropolitan Manila area in accordance with the number of their respective inhabitants and on the basis of a uniform and progressive ratio, and those who, as provided by law, shall be elected through a partyless system of registered national, regional, and sectoral parties or organizations. Number 2. The party list representatives shall constitute 20% of the total number of representatives, including those under the party list, for 3 consecutive terms after the ratification of this Constitution. 1/2 of the seats allocated to party list representatives shall be filled, as provided by law, by selection or election from the labor, peasant, urban poor, indigenous cultural communities, women, youth, and such other sectors as may be provided by law, except the religious sector. Number 3. Each legislative district shall comprise, as far as practicable, contiguous, compact, and adjacent territory. Each city with a population of at least 250,000, or each province shall have at least 1 representative. 4. Within 3 years following the return of every census, the Congress shall make a reappointment of legislative districts based on the standards provided in the section. Section 6. No person shall be a member of the House of Representatives unless he is a natural born citizen of the Philippines and on the day of the election is at least 25 years of age, able to read and write, and except the party list representatives, a registered voter in the district in which he shall be elected, and a resident thereof for a period of not less than 1 year immediately preceding the day of the election. Section 7. The members of the House of Representatives shall be elected for a term of 3 years, which shall begin, unless otherwise provided by law, at noon on the 30th day of June next following their election. No member of the House of Representatives shall serve for more than 3 consecutive terms. Voluntary renunciation of the office of any length of time shall not be considered as an interruption in the continuity of his service for the full term for which he was elected. Section 8. Unless otherwise provided by law, the regular election of the senators and the members of the House of Representatives shall be held on the second Monday of May. Section 9. In case of vacancy in the Senate or in the House of Representatives, a special election may be called to fill such vacancy in the manner prescribed by law. But the senator or member of the House of Representatives thus elected shall serve only for the unexpired term. Section 10. The salaries of senators and members of the House of Representatives shall be determined by law. No increase in said compensation shall take effect until after the expiration of the full term of all the members of the Senate and the House of Representatives approving such increase. Section 11. A senator or a member of the House of Representatives shall, in all offenses punishable by not more than 6 years' imprisonment, be privileged from arrest while the Congress is in session. No member shall be questioned nor be held liable in any other place for any speech or debate in the Congress or in any committee thereof. Section 12. All members of the Senate and the House of Representatives shall, upon assumption of office, make a full disclosure of their financial and business interests. They shall notify the House concerned of a potential conflict of interest that may arise from the filing of a proposed legislation of which they are authors. Section 13. No senator or member of the House of Representatives may hold any other office or employment in the government, or any subdivision, agency, or instrumentality thereof, including government-owned or controlled corporations or their subsidiaries, during his term without forfeiting his seat. Neither shall he be appointed to any office which may have been created, or the emoluments thereof increased during the term for which he was elected. Section 14. No senator or member of the House of Representatives may personally appear as counsel before any court of justice or before the electoral tribunals or quasi-judicial and other administrative bodies. Neither shall he directly or indirectly be interested financially in any contract with or in any franchise or special privilege granted by the government or any subdivision, agency, or instrumentality thereof, including any government-owned or controlled corporation or its subsidiary, during his term of office. He shall not intervene in any matter before any office of the government for his pecuniary benefit or where he may be called upon to act on account of his office. Section 15. The Congress shall convene once every year on the fourth Monday of July for its regular session, unless a different date is fixed by law, and shall continue to be within session for such number of days as it may be determined until 30 days before the opening of its next regular session, exclusive of Sundays, Saturdays, and legal holidays. The President may call a special session at any time. Section 16. Number 1. The Senate shall elect its President and the House of Representatives its Speaker by a majority vote of all its respective members. Each House shall choose such other officers as it may deem necessary. Number 2. A majority of each House shall constitute a quorum to do business, but a smaller number may adjourn from day to day and may compel the attendance of absent members in such manner and under such penalties as such House may provide. Number 3. Each House may determine the rules of its proceedings, punish its members for disorderly behavior, and with the concurrence of 2/3 of its members, suspend or expel a member. A penalty of suspension, when imposed, shall not exceed 60 days. Number 4. Each House shall keep a journal of its proceedings and from time to time publish the same, excepting such parts as may be, in its judgment, affect national security, and the yeas and nays on any question shall, at the request of 1/5 of the members present, be entered in the journal. Each House shall also keep a record of its Proceedings. Number 5. Neither house during the sessions of the Congress shall, without the consent of the other, adjourn for more than 3 days, nor to any other place than that in which the two houses shall be sitting. Section 17. The Senate and the House of Representatives shall each have an electoral tribunal, which shall be the sole judge of all contests relating to the election, returns, and qualifications of their respective members. Each electoral tribunal shall be composed of 9 members, 3 of whom shall be justices of the Supreme Court, to be designated by the Chief Justice, and the remaining 6 shall be members of the Senate or the House of Representatives, as the case may be, who shall be chosen on the basis of proportional representation from the political parties and the parties or organizations registered under the partyless system represented therein. The senior justice in the Electoral Tribunal shall be its chairman. Section 18. There shall be a commission and appointments consisting of the President of the Senate as an ex officio chairman, 12 senators, and 12 members of the House of Representatives, elected by each House on the basis of proportional representation from the political parties and parties or organizations registered under the partyless system represented therein. The chairman of the commission shall not vote, except in case of a tie. The commission shall act on all appointments submitted to it within 30 session days of the Congress from their submission. The commission shall rule by a majority vote of all the members. Section 19. The electoral tribunals and the commission and appointments shall be constituted within 30 days after the Senate and the House of Representatives shall have been organized with the election of the President and the Speaker. The Commission on Appointments shall meet only while the Congress is in session, at the call of its chairman or a majority of all its members, to discharge such powers and functions as are herein conferred upon it. Section 20. The record and books of accounts of the Congress shall be preserved and be open to the public in accordance with law, and such books shall be audited by the Commission on Audit, which shall publish annually an itemized list of amounts paid to and expenses for each member. Section 21. The Senate or the House of Representatives or any of its respective committees may conduct inquiries in aid of legislation in accordance with its duly published rules of procedure. The rights of persons appearing in or affected by such inquiries shall be respected. Section 22. The heads of departments may, upon their own initiative, with the consent of the President or upon the request of either House, as the rules of each House shall provide, appear before and be heard by such House on any matter pertaining to their departments. Written questions shall be submitted to the President of the Senate or the Speaker of the House of Representatives at least 3 days before their scheduled appearance. Interpellations shall not be limited to written questions but may cover matters related thereto. When the security of the state or the public interest so requires and the President so states in writing, the appearance shall be conducted in executive session. Section 23, number 1. The Congress, by a vote of 2/3 of both Houses in joint session assembled, voting separately, shall have the sole power to declare the existence of a state of war. Number 2. In times of war or other national emergency, the Congress may, by law, authorize the President for a limited period and subject to such restrictions as it may prescribe, to exercise powers necessary and proper to carry out a declared national policy. Unless sooner withdrawn by resolution of the Congress, such powers shall cease upon the next adjournment thereof. Section 24. all appropriation, revenue, or tariff bills, bills authorizing increase of the public debt, bills of local application, and private bills shall originate exclusively in the House of Representatives, but the Senate may propose or concur with amendments. Section 25, number 1. The Congress may not increase the appropriations recommended by the President for the operation of the government as specified in the budget. The form, content, and manner of preparation of the budget shall be prescribed by law. Number 2. No provision or enactment shall be embraced in the General Appropriations Bill unless it relates specifically to some particular appropriation therein. Any such provision or enactment shall be limited in its operation to the appropriation to which it relates. Number 3. The procedure in approving appropriations for the Congress shall strictly follow the procedure for approving appropriations for other departments and agencies. Number 4. A special appropriations bill shall specify the purpose for which it is intended and shall be supported by funds actually available as certified by the National Treasurer or to be raised by a corresponding revenue proposal therein. Number 5. No law shall be passed authorizing any transfer of appropriations. However, the President of the Senate, the Speaker of the House of Representatives, the Chief Justice of the Supreme Court, and the heads of constitutional commissions may, by law, be authorized to augment any item in the General Appropriations Law for their respective offices from savings in other items of their respective appropriations. Number 6. Discretionary funds appropriated for particular officials shall be disbursed only for public purposes to be supported by appropriate voters and subject to such guidelines as may be prescribed by law. Number 7. If, by the end of any fiscal year, the Congress shall have failed to pass the General Appropriation Bill for the ensuing fiscal year, the General Appropriations Law for the preceding fiscal year shall be deemed reenacted and shall remain in force in effect until the General Appropriations Bill is passed by the Congress. Section 26, number 1. Every bill passed by the Congress shall embrace only one subject, which shall be expressed in the title thereof. Number 2. No bill passed by either house shall become a law unless it has passed 3 readings on separate days, and printed copies thereof in its final form have been distributed to its members 3 days before its passage, except when the President certifies to the necessity of its immediate enactment to meet a public calamity or emergency. Upon the last reading of a bill, no amendment thereto shall be allowed, and the vote thereon shall be taken immediately thereafter, and the yeas and nays entered in the journal. Section 27. Every bill passed by the Congress shall, before it becomes a law, be presented to the President. If he approves the same, he shall sign it. Otherwise, he shall veto it and return the same with his objections to the House where it originated, which shall enter the objections at large in its journal and proceed to reconsider it. If after such reconsideration 2/3 of all the members of such House shall agree to pass the bill, it shall be sent, together with the objections, to the other House by which it shall likewise be reconsidered. And if approved by 2/3 of all the members of that House, it shall become a law. In all such cases, the votes of each House shall be determined by yeas or nays, and the names of the members voting for or against shall be entered in its journal. The President shall communicate his veto of any bill to the House where it originated within 30 days after the date of receipt thereof. Otherwise, it shall become a law as if he had signed it. Number 2. The President shall have the power to veto any particular item or items in appropriation, revenue, or tariff bill, but the veto shall not affect the item or items to which he does not object. Section 28. The rule of taxation shall be uniform and equitable. The Congress shall evolve a progressive system of taxation. Number 2. The Congress may by law authorize the President to fix within specified limits and subject to such limitations and restrictions as it may impose tariff rates, import and export quotas, tonnage, wharfage dues, and other duties or imposts within the framework of the National Development Program of the government. Number 3. Charitable institutions, churches, and personages or convents appertinent thereto, mosques, nonprofit cemeteries, and all lands, buildings, and improvements actually directly and exclusively used for religious, charitable, or educational purposes shall be exempt from taxation. Number 4. No law granting any tax exemption shall be passed without the concurrence of a majority of all the members of the Congress. Section 29. Number 1. No money shall be paid out of the Treasury except in pursuance of an appropriation made by law. Number 2. No public money or property shall be appropriated, applied, paid, or employed directly or indirectly for the use, benefit, or support of any sect, church, denomination, sectarian institution, or system of religion, or any priest, preacher, minister, other religious teacher, or dignitary as such, except when such priest, preacher, minister, or dignitary is assigned to the armed forces or to any penal institution or government orphanage or leprosarium. Number 3. All money collected on any tax levied for a special purpose shall be treated as a special fund and paid out for such purpose only. If the purpose for which a special fund was created has been fulfilled or abandoned, the balance, if any, shall be transferred to the general funds of the government. Section 30. No law shall be passed increasing the appellate jurisdiction of the Supreme Court as provided in this Constitution without its advice and concurrence. Section 31. No law granting a title of royalty or nobility shall be enacted. Section 32. The Congress shall as early as possible provide for a system of initiative and referendum and the exceptions therefrom whereby the people can directly propose and enact laws or approve or reject any act or law or part thereof passed by the Congress or local legislative body after the registration of a petition therefore signed by at least 10% of the total number of registered voters, of which every legislative district must be represented by at least 3% of the registered voters thereof. Let me repeat that. Section 32. The Congress shall as early as possible provide for a system of initiative and referendum and the exceptions therefrom whereby the people can directly propose and enact laws or approve or reject any act or law or part thereof passed by the Congress or local legislative body after the registration of a petition therefore signed by at least 10% of the total number of registered voters, of which every legislative district must be represented by at least 3% of the registered voters thereof. So that is the end of the Legislative Department, Article 6. Let's now check some notes on the reviewer, which is supposed to be for the 2020 bar exam. What is pork barrel? Pork barrel refers to an appropriation of government spending meant to localize projects and secured solely or primarily to bring money to a representative's district. Pork barrel has been commonly referred to as lump sum discretionary funds of the members of the legislature, although its usage would evolve in reference to certain funds of the executive. Belgica versus Ochoa 02-08566, November 19, 2013. Another, in May 2017, President Duterte issued Proclamation number 21-6, declaring a state of martial law and the suspension of the privilege of the writ of habeas corpus in the whole of Mindanao, effective for 60 days, to address the rebellion mounted by the Maute Group and the Abu Sayyaf. The proclamation was approved by Congress. In June 2017, the President requested Congress to extend the effectivity of Proclamation number 21-6 up to December 2017, which the Congress granted. President Duterte requested another extension of the proclamation for a year. Again, Congress approved the extension. AAA questions the validity of the extensions, arguing that the Constitution only allows one-time extension. What is your decision? The subsequent extensions are valid and constitutional. Congress has the power to extend and determine the period of martial law and the suspension of the privilege of writ of habeas corpus. Section 18, Article 7 of the Constitution is silent as to how many times Congress may extend the proclamation of martial law. The only limitations are that the extension should be upon the President's initiative. 2. That it should be grounded on the persistence of the invasion or rebellion and the demands of public safety. And 3. That it is subject to the court's review of the sufficiency of its factual basis upon the petition of any citizen. The said provision did not fix the period of extension. The Constitution clearly gave the Congress authority to decide the duration of state of martial law. Lagman versus Pimentel. Now on the qualification and composition of members. House of Congress. The COMELEC issued Resolution number 6486 to implement Section 36 letter D of RA 9165, or the Comprehensive Dangerous Drugs Act of 2002, prescribing the rules and regulations on the mandatory drug testing of candidates for public office in connection with the May 10, 2020 synchronized national and local elections. Pepe, a senator and a candidate for re-election in the 2020 elections, filed a petition to nullify Section 36 letter G of RA 9165 and COMELEC Resolution number 6486 for being unconstitutional because they impose a qualification for candidates for senators in addition to those already provided for in the Constitution. According to Pepe, Section 3, Article 6 of the Constitution only prescribes a maximum of 5 qualifications for one to be a candidate for, elected to, and be a member of the Senate, to wit: 1. Citizenship, 2. Voter registration, 3. Literacy, 4. Age, 5. Residency. He says that both the Congress and COMELEC, by requiring a senatorial aspirant to undergo a mandatory drug test, create an additional qualification that all candidates for senator must first be certified as drug-free. He adds that there is no provision in the Constitution authorizing the Congress or COMELEC to expand the qualification requirements of candidates for senator. What do you think? Section 36G of RA 9165 is unconstitutional. The qualifications of members of the Congress are exclusive, and as such, the Congress cannot validly amend or otherwise modify these qualification standards, as it cannot disregard, evade, or weaken the force of a constitutional mandate, or alter or enlarge the Constitution. In the same vein, the COMELEC cannot, in the guise of enforcing the administering election laws or promulgating rules and regulations to implement Section 36 letter G, validly impose qualifications on candidates for senator in addition to what the Constitution prescribes. Here, Section 36 letter G of RA 9165 effectively enlarges the qualification requirements enumerated in Section 3, Article 6 of the Constitution. It unmistakably requires a candidate for senator to be certified illegal drug clean as a precondition to the validity of a certificate of candidacy for senator, or with like effect, a condition sine qua non to be voted upon, and if proper, be proclaimed as senator-elect. SJS versus Dangerous Drugs Board, GR number 157870, November 3, 2008. House of Representatives. The election of the Speaker of the House of Representatives was held with 252 members voting for A and 8 members voting for B, the second highest of votes. A long-standing tradition of the House is that the candidate who garnered the second highest numbers of votes for speakership automatically becomes the minority leader. Pursuant to such tradition, B should be declared and recognized as the minority leader. However, those who did not vote for Speaker A convened and elected X as the minority leader. A petition for Mandamus was filed insisting that B should be considered or recognized as the minority leader in light of the long-standing tradition. Will the petition of Mandamus lie? No, Mandamus will not lie. The Senate shall elect its president and the House of Representatives, its speaker by a majority vote of its respective members. Each house shall choose such other officers as it may deem necessary. Constitution 1987, Article 6, Section 16, Paragraph 1. Section 16, Number 3, Article 6 of the Constitution vests in the House of Representatives the sole authority to determine the rules of its proceedings. These legislative rules, unlike statutory laws, do not have the imprints of permanence and obligatoriness during their effectivity. In fact, they are subject to revocation, modification, or waiver at the pleasure of the body adopting them. Being merely matters of procedure, their observance are of no concern to the courts, for said rules may be waived or disregarded by the legislative body at will, upon the concurrence of a majority of the House of Representatives. As such, the method of choosing who will be such other officers is merely a derivative of the exercise of the prerogative conferred by the aforequoted constitutional provision. Bagilat versus Alvarez, GR 227757, July 25, 2017. Therefore, in this case, X is rightfully elected as the minority leader. On the partyless system, can the COMELEC deny the application for registration filed by ABC, an organization composed of men and women who identify themselves as lesbians, gays, bisexuals, or transgender individuals, based on moral grounds? Answer is no. The COMELEC cannot deny registration of ABC based on moral grounds. In Ang Ladlad LGBT Party versus COMELEC, GR 190582, April 8, 2010, the Supreme Court ruled that the enumeration of marginalized and underrepresented sectors is not exclusive. The crucial element is not whether a sector is specifically enumerated, but whether a particular organization complies with the requirements of the Constitution and RA 7941. The denial of the registration on purely moral grounds amounts more to a statement of dislike and disapproval of homosexuals rather than a tool for further any substantial public interest. Note, religious sector cannot participate in the partyless system. Article 8, Section 5, Number 2 of the Constitution, but religion cannot be used to disqualify a party, organization, or coalition. On privileges, inhibitions, and disqualifications, in determining who may participate in a partyless election, what are the parameters to be followed? The parameters are 1. 3 different groups may participate in the partyless system. 1. National parties or organizations. 2. Regional parties or organizations. And 3. sectoral parties or organization. Number 2, national parties or organizations and regional parties or organizations do not need to organize along sectoral lines and do not need to represent any marginalized and underrepresented sector. 3. Political parties can participate in party list elections provided they register under the party list system and do not fill candidates in legislative district elections. 4. Sectoral parties or organizations may either be marginalized and underrepresented or lacking in well-defined political constituencies. 5. A majority of the members of sectoral parties or organizations that represent the marginalized and underrepresented must belong to the marginalized and underrepresented sector they represent. Similarly, a majority of the members of sectoral parties or organizations that lack well-defined political constituencies must belong to the sector they represent. The nominees of sectoral parties or organizations that represent the marginalized and underrepresented, or that represent those who lack well-defined political constituencies, either must belong to their respective sectors or must have a track record of advocacy for their respective sectors. The nominees of national and regional parties or organizations must be bona fide members of such parties or organization. And finally, national, regional, and sectoral parties or organizations shall not be disqualified if some of their nominees are disqualified, provided that they have at least one nominee who remains qualified. Atong Paglawom versus Kamalek, GR 203766, April 2nd, 2013. Note, a political party, whether major or not, that fields candidate in legislative district elections can participate in party list elections only through its sectoral wing that can separately register under the party list system. The sectoral wing is by itself an independent sectoral party and is linked to a political party through a coalition. Next, during the Senate hearing regarding the overpriced Makati City Hall parking building, some references were made on a 350-hectare estate in Batangas, also referred to as Hacienda Pinay, supposedly owned by XX. During media interviews in between the hearings and in response to media's request for him to comment on the matter, Senator YY expressed his opinion that XX appears to be a nominee or front or acting as dummy of the actual beneficial owner, former Vice President Pinay. XX sued for damages against Senator YY's defamatory and libelous statements. May Senator YY invoke the parliamentary immunity? The answer is no. Senator YY cannot invoke parliamentary immunity. The privilege of speech or debate under Section 11, Article 6 of the Constitution covers speech delivered in Senate or any of its committees, spoken in the course of any debate in said fora, or made in the official discharge or performance of duties as a senator. The statement must be part of or integral to the legislative process. Here, the statements were made during the breaks and gaps of the hearing, not delivered in Senate committees, not spoken during a debate therein. They were also not made in the official discharge of duties as a senator. To participate in or respond to media interviews is not demanded for his sworn duty, nor it is a component of the process of enacting laws. Senator YY, therefore, cannot invoke parliamentary immunity. Trillanes 4th versus Honorable Castillo Marigomen, GR 223451, March 14, 2018. Next, Congressman Z filed House Bill number 123 converting the municipality of Santan to City of Sampaguita. A month later, Senator Y filed Senate Bill 456, also converting the municipality of Santan to City of Sampaguita. The HB 123 was approved by the lower house and was subsequently transmitted to the upper house. However, the Senate adopted the version of Senator Y, which was approved by President X, now Mr. CDE, a resident of municipality of Santan, assailed the newly passed law, arguing, among others, that it did not originate exclusively from the House of Representatives as mandated by Section 4, Article 6 of the Constitution, since it had a counterpart in the Senate. Answer: the contention of the petitioner is without merit. A bill of local application, such as one asking for the conversion of a municipality into a city, is deemed to have originated from the House, provided that the bill of the House was filed prior to the filing of the bill in the Senate, even if, in the end, the Senate approved its own version. The filing in the Senate of a substitute bill in anticipation of its receipt of the bill from the House does not contravene the constitutional requirement that a bill of local application should originate in the House of Representatives, for as long as the Senate does not act thereupon until it receives the House bill. Hence, Section 24, Article 6 of the Constitution was not violated. Case Alvarez versus Gingona, GR 118303, January 31, 1996. On quorum and voting majorities, illustration: Senator A is abroad for a family vacation. Senator B is sick and is in a comatose condition, confined in the Philippines. Senator C is imprisoned. Determine the number of senators necessary to constitute a quorum to do business. The basis in determining the existence of a quorum in the Senate shall be the total number of incumbent senators who are in the country and within the coercive jurisdiction of the state. Avellino versus Cuenca, GR number L2821, March 4, 1949. Thus, Senator A is not counted in determining the quorum. However, Senators B and C are still counted since they are within the coercive jurisdiction of the state. On the assumption that all the 24 seats in the Senate are filled, the presence of 13 senators constitutes a quorum to do business. On appropriation and realignment, Land Transportation Office formulated the Motor Vehicle License Plate Standardization Program, or MVPSP, to supply new license plates for both old and new vehicle registrants. The program, however, did not appear as an item in the General Appropriations Act of 2014. The increased appropriation of 4.8 billion was instead allocated under the item Motor Vehicle Registration and Driver's Licensing Regulatory Services, or MFO2. Congressman XX and YY argued that since MVPSP did not appear as an item in the 2014 GAA, the use of its funds allocated for the MF02 amounted to an unconstitutional transfer of appropriations prohibited by Section 25, Number 5 of Article 6 of the Constitution, which provides that no law shall be passed authorizing any transfer of appropriation. Are Congressman XX and YY correct? No, they are not correct. To be valid, an appropriation must indicate a specific amount and a specific purpose. However, the purpose may be specific even if it is broken down into different related subcategories of the same nature. Here, the appropriation for motor vehicle registration naturally and logically included plate making inasmuch as plate making was an integral component of the registration process. Thus, since the 2014 GAA itself contained the direct appropriation necessary to implement the MVPSP, there was no unconstitutional transfer of funds. De la Cruz versus Ochoa Jr., GR 219683, January 23, 2018. Next, Career Executive Service Board, or CESB, granted to its officials and employees various monetary benefits. The Commission on Audit disallowed the grant of monetary benefits like birthday bonus, fringe benefits, Christmas grocery, and retirement pay rank and file employees on the ground that the grant has no legal support. CESB argued that it needed no new appropriation inasmuch as its agency savings were utilized for the grant of such benefits. Is CESB correct? No, CESB is not correct. Section 29, number 1 of Article 6 of the Constitution ordains that no money shall be paid out of the Treasury except in pursuance of an appropriation made by law. The only exception is found in Section 25, number 5, Article 6 of the Constitution, by which the President of the Philippines, the President of the Senate, the Speaker of the House of Representatives, the Chief Justice of the Philippines, and the heads of the constitutional commissions are authorized to transfer appropriations to augment any item in the GAA for their respective offices from the savings in other items of their respective appropriations. Here, the CESB is not among the officials or agencies authorized to transfer their savings in other items of its appropriation. The Commission, or CSC, with the CSC being the office vested with fiscal autonomy by the Constitution, the CESB's use of its savings to cover the CNA benefits for its employees had no legal basis. Career Executive Service, Board versus COA, GR 212348, June 19, 2018. Next, in 2018, Congress enacted RA 8439, granting additional allowances and benefits, or the Magna Carta benefits, to the covered officials and employees of the Department of Science and Technology, or DOST. Under RA 8439, the funds of the payment of the Magna Carta benefits are to be appropriated by the General Appropriations Act, or GAA, of the year following the enactment of RA 8439. However, the amount necessary for its full implementation had not been provided in the GAA, prompting the Secretary of DOST to request the Office of the President, or OP, through a memorandum for the authority to utilize the DOST's savings to pay the Magna Carta benefits. The Office of the President granted such request. XX argues that such authorization operated as a continuing endorsement of the use of savings to convert the Magna Carta benefit in succeeding calendar year. Is the contention of XX correct? The answer is no. XX is not correct. In the funding of current activities, projects, and programs, the general rule should still be that the budgetary amount contained in the appropriations bill is the extent Congress will determine as sufficient for the budgetary allocation for the proponent agency. Here, although the memorandum was silent as to the period covered by the request for authority to use the DOST's savings, it was clear, just the same, that the memorandum encompassed only calendar year 2019. The memorandum could only be read as an authority covering the limited period exclusive of calendar year 2019. The text of the memorandum was also bereft of any indication that the authorization was to be indefinitely extended to any calendar year beyond calendar year 2019. Nazareth versus Villar, GR 188635, January 29, 2013. Next, does the Constitution prohibit cross-border augmentation? Yes. Cross-border augmentations from savings are prohibited by the Constitution by providing that the President of the Senate, the Speaker of the House of Representatives, the Chief Justice of the Supreme Court, and the heads of the constitutional commissions may be authorized to augment any item in the GAA for their respective offices. Section 25, number 5 of Article 6 of the Constitution has delineated borders between their offices such that funds appropriated for one office are prohibited from crossing over to another office, even in the guise of augmentation of a deficit item or items. Thus, we call such transfers of funds cross-border transfer or cross-border augmentations. Cross-border transfers, whether as augmentation or as aid, were prohibited under Section 25, number 5 of the Constitution. Arolo versus Aquino III, GR 29287, July 1, 2014. Note, however, that the phrase respective offices used in Section 25, number 5 refers to the entire executive with respect to the President, the Senate with respect to the Senate President, the House of Representatives with respect to the Speaker, the Judiciary with respect to the Chief Justice, the Constitutional Commissions with respect to their respective chairperson. On legislative inquiries and oversight function, XX, a first-year law student of the University of Mang Tomas, or UMT, died allegedly due to hazing conducted by the YY fraternity of the same university. An investigation in aid of legislation was conducted by the Senate Committee on Public Order and Dangerous Drugs. AA, an alleged member of YY fraternity, was subpoenaed. In the course of the hearing, AA repeatedly failed to answer the questions and invoked his right against self-incrimination. As a result, he was cited by the Senate in contempt. Considering that the Senate is a continuing body, may it detain AA indefinitely? The answer is no. It cannot detain AA indefinitely. Section 21, Article 6 of the Constitution provides that the Senate or the House of Representatives or any of its respective committees may conduct inquiries in aid of legislation in accordance with its duly published rules of procedure. The rights of persons appearing in or affected by such inquiries shall be respected. The period of imprisonment under the inherent power of contempt by the Senate during inquiries in aid of legislation should only last until the termination of the legislative inquiry under which the said power is invoked. The legislative inquiry of the Senate terminates on two instances: one, upon the approval or disapproval of the committee report, or two, upon the expiration of Congress. An indefinite and unspecified period of detention will amount to excessive restriction and will certainly violate any person's right to liberty. Balag versus Senate, GR number 234608, July 3, 2018. On the question of impeachment, on June 2, 2019, President X filed an impeachment complaint against Chief Justice Y and 7 associate justices of the Supreme Court for culpable violation of the Constitution, betrayal of the public trust, and other high crimes. The complaint was endorsed by 3 congressmen and was referred to the House Committee on Justice on August 5, 2019, in accordance with Section 3, Number 2 of Article 11 of the Constitution. The House Committee on Justice ruled on October 13, 2019, that the impeachment complaint was sufficient in form, but voted to dismiss the same on October 22, 2019, for being insufficient in substance. On October 23, 2019, a second impeachment complaint was filed with the Secretary General of the House against Chief Justice Y. This second impeachment complaint was accompanied by a resolution of endorsement or impeachment signed by at least 1/3 of all members of the House of Representatives. Is the filing of the second impeachment complaint constitutional? The answer is no. The filing of the second impeachment complaint is unconstitutional. Under Section 3, Number 5 of Article 11 of the Constitution, no impeachment proceedings shall be initiated against the same official more than once within a period of 1 year. The framers intended initiation to start with the filing of the complaint. The provision means that no second verified complaint may be accepted and referred to the Committee on Justice for action. In this case, the second impeachment complaint against Chief Justice Y was filed on October 23, 2019, or 4 months and 3 weeks after the filing on June 2, 2019 of the first complaint. Hence, the filing of the second impeachment complaint is unconstitutional. Francisco versus House of Representatives, GR 160-261, November 10, 2003. Finally, electoral tribunals. O assumed office as the party list representative of Matapang party list in the House of Representatives, but was later on expelled by the party list for disloyalty. The party list filed with the COMELEC a petition against O praying that he be ordered to vacate the office of Matapang in the House of Representatives. The Comelec upheld O's expulsion from Matapang. Does the Comelec have jurisdiction over the expulsion of a member of the House of Representatives from his party's organization? The answer is no. The Comelec does not have jurisdiction. Section 17, Article 6 of the Constitution vests the HRET with jurisdiction to resolve questions on the qualification of members of the House of Representatives. Since the Comelec has proclaimed Matapang as a winning partyless group, Petitioner O took his oath and has assumed office in the House of Representatives. It is already the HRET and not the Comelec that has jurisdiction. Moreover, the petition for O's expulsion from the HOR is anchored on his expulsion from Matapang, which necessarily affects his title as member of Congress. Thus, the validity of petitioner's O's expulsion from Matapang is integral to the issue of his qualification to sit in Congress, over which the HRET has exclusive jurisdiction. Lico versus Comelec, GR number 205505, September 29, 2015. And lastly, on tax exemptions. While tax exemptions are strictly construed against the taxpayer, the government should not misuse technicalities to keep money it is not entitled to. Philippine Airlines versus Commissioner of Internal Revenue, GR numbers 206079 to 80, January 17, 2018. While tax amnesty is in the nature of a tax exemption, which is strictly construed against the taxpayer, the court cannot disregard the plain text of RA 9480, Commissioner of Internal Revenue versus Covanta Energy Philippine Holdings Incorporation, GR number 203160, January 24, 2018. Note, considering that CEFI, or Covanta Energy Philippine Holdings Incorporation, completed the requirements and paid the corresponding amnesty tax, it is considered to have totally complied with the tax amnesty program. As a matter of course, CEFI is entitled to the immediate enjoyment of the immunities and privileges of the tax amnesty program. Nonetheless, the court emphasizes that the immunities and privileges granted to taxpayers under RA 9480 is not absolute. It is subject to a resolutory condition insofar as the taxpayer's enjoyment of the immunities and privileges of the law is concerned. These immunities cease upon proof that they underdeclared their net worth by 30%. Commissioner of Internal Revenue versus Covanta Energy Philippine Holdings Incorporated, GR number 203160, January 24, 2018. So this is what we have on our reviewer on Legislative Department. If you have new reviewer or a much detailed and comprehensive one, do share it to us via our email account. Thanks.